Hello everyone. Welcome back again to this unique platform of the law. And I would once again welcome you all to this YouTube platform of the law, right? So we are continuing on the second part, and I will be carrying forward with what I have left in yesterday's session. And we were discussing on right to life, the fundamental right. See, we had seen yesterday in terms of that how actually the law evolved itself in terms of that is right to life. How we have reached this stage actually in terms of fundamental right, that is right to life. So way back I took you way back to that is called the aspect of Magna Carta, the fundamental and the foundational document of the year 1215, right? And we've seen that how rule of law, the due process of law, all that were the guiding force that were actually coming from Magna Carta. Apart from that, we have also discussed that how it had the impact on Indian legal system. We had discussed, we had emphasized on three articles per se. That is Article 14, which talks about right to equality. We had talked on Article 21, right to life, and also we have discussed on Article 19, that is a speech and expression and all that. So we had discussed on these aspects, and we strongly emphasized, emphasized on the point of Article 21, that is right to life. So when we see the legal perspective, the entire law cannot be said, but in majority of cases, it is the human centric aspect that is taken care of. And when we talk about human centric aspect, definitely what is the nexus it will be having, what the connection it will be having into the right of life. And right from the case of Maneka Gandhi versus Union of India, which overturned the aspect of Gopalan case, A.K. Gopalan versus State of Madras, which said that Article 14, 19 and 21 are mutually exclusive. This aspect was overturned in the case of landmark case of Maneka Gandhi, and it held that no, they are not mutually exclusive, rather they had to be complying with one another. What the court emphasized in A.K. Gopalan case, that everything that is done by adopting the process of law will suffice the requirement. So for seeing if someone is deprived of his right to life or liberty, in terms of Article 21, we do not need to see Article 14, and we do not need to cross check on the perspective of that is called right to Article 19. But surprisingly, when you see the Maneka Gandhi case, it adopted a broad concept. The Gopalan case was based rather on narrower concept. Now in Maneka Gandhi, it changed its perspective. Honorable Apex Court changed its perspective and said that we have to have broader approach to give a broader ambit to the right of life. So what is right to life, what has been provided in few words in Article 21 cannot be very much limited. So adopting a very broader approach and taking the assistance of due process that is provided in American Constitution. See, due process is not the aspect of Indian Constitution. It is rather procedure established by law. But taking the assistance of due process, which is the part of the American Constitution, the Honorable Apex Court went to say that if you are depriving of the fundamental right, it should also comply the due process. And if any executive action, it is hampering the very fundamental right, like Article 19(1)(d), right to move freely and all that. So if it is hampering that, again, if the statute doesn't provide, the executive action doesn't provide the aspect of fairness, the aspect of equality, the fairness must be brought by adopting the process of principle of natural justice. So where the executive action doesn't provide the aspect of opportunity of hearing, we will apply the concept of principle of natural justice, and he will have to be given a chance of proper hearing that why he has been deprived of such a right. So in Maneka Gandhi, her passport was confiscated and the very action was challenged before Honorable Apex Court, and our Apex Court held that yes, such executive action will have to be at least in the compliance of principle of natural justice. Meaning by that the party affected must have the right to meet the grievance. Why the executive is taking such an action, why the government is taking such an action, it must be by proper notice. She should be in a position to reply the same, like that. And since it was not done, it was strongly deprecated by Honorable Apex Court. Now I will be taking your attention one by one to the cases starting from A.K. Gopalan, what we have in very short discussed right now. So let me drag your attention to first of all the case of A.K. Gopalan. See, what is the Article 21 requisite in terms of the procedure established by law? Procedure established by law, you have to understand that what is the requisite of Article 21, that is right to life, that no person shall be deprived, no person shall be deprived of his either life or personal liberty. Personal liberty, he shouldn't be deprived. And if you are depriving him, one thing you have to bear it in mind, the executive action or the state action. If it is in a position to deprive the very citizen or the non-citizen even, Article 21 is there for even non-citizens. So if you are depriving, it shouldn't be, or it should accept according to the procedure established by law. It should be according to procedure established by law. Now, what is the aspect of procedure established by law? What do you understand by, or what could be the requisite of procedure established by law? Established by law. What I mean to say that actually, what are the things that will suffice the requirement of the procedure established by law? So at number one, if I can keep is procedure established by law, that such law should be made, law shall be made, it shall be made by at least a competent authority. Competent authority. The number one, that is, number two, what you require it should provide a procedure to deprive. It should provide a procedure to deprive the same. Procedure to deprive the same. And the very procedure, keep it in mind, must be followed. It must be followed, right? So these are the three requisites. These are the three requisites of the word procedure established by law. Now, Gopalan case insisted on procedure established by law, but it was still said that it was a narrower perspective. As it said that Article 19 and 14 are mutually exclusive to that provided under Article 21. But it was the Maneka Gandhi case which emphasized that they are not mutually exclusive. It means that if they are not mutually exclusive and you are depriving someone from right to life, you will have to also meet the requirements of 19. You will also have to meet the requirements of Article 14, which talks about right to equality, equality in terms of equality before law, or that is equal protection of law. Equal protection of law. So let me put the facts of A.K. Gopalan. So A.K. Gopalan case, Mr. Gopalan pleaded, it was pleaded on the part of Mr. Gopalan that my detention order actually he was passed with detention order. Detention order is violative of, it is violating Article 21, it is violating Article 14, as well article that is called 19(1)(d), which talks about right to freely move. 19(1)(d) का violation है. As such was the plea. And what he required, what he pleaded before the court, that it must be by adopting due process. It must be by adopting due process. Now, the due process was seen very narrowly. The court went to say that, court held that law depriving a person of Article 21 should not satisfy the requisites of Article 14 and requisites of Article 19, since they are mutually exclusive. Since they are mutually exclusive, the only aspect that can be seen at the best is the procedure established by law. So if the procedure established by law doesn't provide for the aspect of fairness, then we are helpless. So this is how it was seen narrowly actually, and was criticized in later judgments, and especially in Maneka Gandhi, which overturned on this point. See, Maneka Gandhi case overturned on this aspect, that Article 14, Article 19 and Article 21, they are not mutually exclusive. They are not mutually exclusive. So if one is affected, the other has to be cross-checked that there is a compliance of the same or not. Right? So in Maneka Gandhi case, the Gopalan's case was overturned. And if I drag your attention to the Maneka Gandhi case, or the facts of Maneka Gandhi case, the Maneka Gandhi, her passport was confiscated. Her passports were confiscated by the government. Now these confiscation was challenged into the court of law by saying that it deprives a person's personal liberty. It deprives a person personal liberty, and that is guaranteed by Article 21. So personal liberty को ये affect कर रहा है, ठीक है? And this should always be by just, fair and reasonable action. Just, fair and reasonable action. So this was the pleading before Honorable Apex Court. And since there was a denial of hearing to the very party, so it did not comply that aspect. It is violative of Article 14. Now, not only violative of Article 14, it was also the violation of Article 19(1)(d). So taking all this account, what the court held, कि Article 14, 19 and 21 are not mutually exclusive, as held in Gopalan case, and it said that they are actually to be seen in toto. They must be complying with one another. So if you are depriving a citizen of its personal liberty, it must be by adopting due process, which is discussed in the American Constitution. By taking the help of due process, the court emphasized that every executive action which deprives a person's personal liberty must meet the requisites of due process. Must meet the requisites of due process. Meaning by, if the executive action and the procedure established by law doesn't provide for the hearing aspect, the due process, by adopting due process, the court held that there must be an aspect of proper hearing. So if the executive action doesn't provide any such opportunity, the principle of natural justice is automatically get attracted to the situation. So these were the outcomes of Gopalan and subsequently in Maneka Gandhi case. See, it is a very broad aspect, as I discussed yesterday, that there is a long list you can think of in terms of right to life under Article 21. And if I particularly talk It is some aspects that I can discuss here. It is a very broad topic and can be discussed for a number of days. But some topics that I can discuss under it. Number one, it can be right to privacy. The landmark case of K.S. Puttaswamy versus Union of India. It can be discussed in terms of right to go abroad, that is still discussed, that is Maneka Gandhi case. Not only that, right to shelter, that is Olga Telly's case, I will be discussing right now. And the list is so long. It talks about right against solitary confinement. It talks about rights of social justice and economic empowerment, right to reputation, right to livelihood, right? These are all associated. Right against handcuffing. The landmark case of Husainara Khatun, which talks about right to speedy trial. Not only that, it is against right against custodial death and right against the delayed execution. So it is a very broad list I can talk about. Not only that, right to have doctor's assistance. Also, the right to have pollution free environment and pollution free water. Not only that, right of health and medical aid, and also about right of under trial prisoners. Right of under trial prisoners. Mr. Sunil Batra, who claimed before writing a letter before Honorable Apex Court, and Apex Court provided guidelines in terms of jail manual and jail laws. So these are the long list that we can discuss. Apart from that, there are still number of topics that can be discussed, but we will be emphasizing on certain very important points one by one. Now let me put it one by one. I will be starting with the landmark case of K.S. Puttaswamy. K.S. Puttaswamy versus Union of India. K.S. Puttaswamy versus Union of India, we all know that the validity of Aadhaar was challenged in this. A serious concern was raised in this case that our information that is provided by means of what we have been providing in Aadhaar before making of Aadhaar can be misused. So the very data must be saved in terms of that. But what we do not discuss in terms of K.S. Puttaswamy, what was also considered in the judgment, what was also apart from this discussed in the judgment, that I would like to put before you. In the K.S. Puttaswamy case, there was a challenge in terms of right to privacy. It was, this judgment is based on the point of right to privacy. So you must have it in mind that right to privacy is nowhere discussed as a fundamental right, especially that is included in right to life. And this was the pleading from the government. The government pleaded that right to privacy is not a part of right to life or fundamental right. So what did the court go for saying that? That right to privacy as fundamental right, it is a fundamental right. It is a fundamental right in terms of Article 21, that is right to life. It is a very fundamental right in terms of Article 21, and it also recognized. See, the Supreme Court went to overrule certain judgments in holding that right to privacy is part of right to life. And it also, what it held in, what I want to actually discuss, it held also recognized, that right of sexual orientation, right of sexual orientation as integral aspect of privacy. Right of sexual orientation as integral aspect of right to privacy. It is also the part of right to privacy. And since the sexual orientation aspect is an integral part of right to privacy, the right to privacy is also the part of right to life. Right to privacy also held that that right to privacy is the right to life. So it is the part of right to life. So this was one aspect that actually I wanted to discuss in terms of K.S. Puttaswamy versus Union of India. Coming to the next case, that is right over one's intimate relation. A very landmark case, Navtej Singh Johar. Navtej Singh Johar. This is based on the core conception of, that is, right to or right over one's sexual or intimate relation. And the case is Navtej Singh Johar. Navtej Singh Johar case versus Union of India. Union of India, what did it provide? See, there was a challenge in the Supreme Court, and the pretext that 377 of Indian Penal Code is violative of this aspect. Violative of this aspect. What they actually pleaded in this case, that if two adult persons want to have consensual sex, especially in terms of LGBTQ community, so they have prayed, they have challenged the very aspect that why the consensual sex shouldn't be allowed. If two adults are consenting each other, 377 provides punishment for unnatural sex. So why not it should be allowed? So the very 377 IPC was challenged. Why it was challenged? Because it criminalized the sexual acts, consensual, better to say, consensual sexual act amongst LGBTQ community. Right? Now this was challenged on the pretext of that it is violative of the very fundamental right, that is right to life. Right to life. Now since it was challenged, the Honorable Court went to held that if it is a consensual sex between the two adults, especially in terms of LGBTQ community, it is not an offense. It is not at all an offense. And it decriminalized on this aspect. It decriminalized. So if there is a consensual sex between the two adults, it is also the part of right to life. It is also the part of right to life. See, one thing you must understand, that how or when this broadening aspect of right to life emerged. So right from the Maneka Gandhi case, the court came in its active mode by recognizing various types of fundamental rights, various types of acts or activities as part of fundamental rights, especially in terms of that is called right to life. And that is why we see number of lists that we discuss or that we debate on the point in terms of right to life. So this was one such. Leading to the next case, which I will be talking on, it is right to livelihood. Right to livelihood. Right to livelihood, and I would be referring the case of Olga Teles. Olga Teles versus Union of India. Sorry, Olga Teles versus Bombay Municipal Corporation. The fact of the case are, there were pavement dwellers, who were actually staying on the pavements. And all of a sudden, the actions from the BMC, the action from the Bombay Municipal Corporation, ruined their years of living, years of the living they had on the pavements, slum dwellers, pavement dwellers, right? So what did the court say? Before monsoon, you are not going to do so. And the one who are residing right from 1976, prior to 1976, must be accommodated. They must be accommodated as they have right to livelihood now. So the accommodation was ordered for them who were staying there right from 1976, and it was ordered that since they have the right to livelihood, and right to livelihood is the part of right to life, and since it is the part of life, now it is the duty of the state, that they may provide now the house and shelters and everything. So this was a landmark case in terms of right to livelihood as a part of right to life. Right to livelihood is the part of right to life. Then come to the next case. Let me come to the next case, which talks about right to health and medical. See, I have been discussing the various topics that we can cover in terms of the right to life. Now, these are the various facets that we can think of in terms of right to life. So, right from starting from A.K. Gopalan case, we have crossed the journey of Maneka Gandhi. We have crossed the journey in terms of Olga Tellis. We have crossed the journey in terms of that is called now Tej Singh Johar. A very important case in the form of K.S. Puttaswamy versus Union of India, which considers right to privacy as right to life. Now we will be discussing the another facet of right to life, which is known as right to health and medical assistance. Medical assistance. See, this case that I am going to discuss is an important case from the purview also of law of tort. And the case is Pandit Paramanand Katara. The case is Pandit Paramanand Katara versus Union of India. What was the fact of the case? The fact of the case was there was a scooterist, a scooter driver, a scooter driver who faced accident. And now he faced accident. Now what was the bad fate of this person? That the hospital he was brought, the private hospital that he was taken, uh, refused to treat him. Refused to treat him. Why he refused to treat him? Because there was aspect of legal and police formality. Legal as well as police formality. Police formality. Now since the hands of the doctor or the doctor prevented itself from treatment, which led to the death of the person, death of that particular accident victim, right? Now a case was filed in the Supreme Court and demanding for that right to life includes the right to health and medical assistance. The private government or private or the government hospital can't refuse the same, and it was held by the Supreme Court that due to legal formalities or police formality, even a private doctor can't refuse to treat that particular person who is in need of care, who is in need of treatment. The police formalities or the statutory formalities can be done later on. But what is the requisite or what is the required at that juncture is the treatment of that person. Treatment of that very person who is the victim right now. And it held that right to health and right to medical assistance is the part of right to life under Article 21. It's the part of right to life under Article 21. Taking another facets of right to life, now let me talk on the next point, that is right to sleep. See, many of us love right to sleep, or many of us love to sleep actually, na? If you are tired, you just want to sleep, you don't want to do anything else. So, is right to sleep the fundamental right? Now, this was the question posed before Honorable Apex Court, that right to sleep is also right part of right to life. And it was held by the Supreme Court, right to sleep is a fundamental right under Article 21, that is right to life. It is a part of right to life. Now, what was the case or which was the case? It is Ray रामलीला मैदान. द केस इज रामलीला मैदान. आप लोगों को याद होगा रामलीला मैदान केस, रामलीला मैदान इंसिडेंट केस वर्सेस होम सेक्रेटरी. So in this case, the court went to held that if somebody is sleeping, you cannot just go and disturb. So here one thing that has to be taken care of, the right to sleep is also a fundamental right. And if someone is sleeping in a very peaceful position without obstructing anything, So he must not be disturbed with the very fundamental right, which is a part of right to life under Article 21. So right to sleep is part of right to life under Article 21. Not only that, now let me drag your attention to the next facet of right to life, and which is known as right to die. A very controversial topic, that is right to die. Is right to die a fundamental right? Is it a part of right to life under Article 21 or not? So the very first case that I would like to put before you is the P. Ratinam case. See, P. Ratinam case went to held that right to die is a fundamental right in terms of right to life under Article 21. Now let me put the facts of the case, that two petitions were filed in the court. The two petitions were filed in the court, and this challenged actually section 309 IPC, which criminalizes attempt to suicide. 309 IPC. Now what happened in this case? What was the ground actually? On the ground of violation of Article 41, on ground of violation of Article 41, sorry, Article 14, Article 14 as well as Article 21. So it actually offended, it actually violated the very Article 14 and Article 21. Now basing on this aspect, the court went to hell that what? Keeping Article 21, and the aspect of PNJ, principle of natural justice, right? Division bench of Supreme Court, what does it held? The DB of Supreme Court, what does it held? DB means the two judges were sitting in the matter and decided the matter, that Article 21 includes right to life, includes right to die. So they had passed the judgment in this way. Now this judgment was overturned in Gyan Kaur case. It was overturned in Gyan Kaur case. The Gyan Kaur says no. Abatement to suicide and attempt to suicide is an offense. So as such we cannot say the right to die is a part of right to life. And the matter was ultimately decided in the case of the Common Cause versus Union of India. Common Cause versus Union of India, in which they went to held that right to die is right to life. Right to die is a part of right to life. So there was a petition right from NGO. NGO filed a petition in the Honorable Apex Court, filed a petition in the form of PIL, public interest litigation, and it was demand from the court to legalize the living will as well as euthanasia, that is passive euthanasia. See, what is recognized in India is the passive euthanasia. Right? The active is still not followed. What we follow is passive euthanasia, but must be with a strict legal compliance. Now, when we are discussing the aspect of euthanasia, I have to discuss here something more, that why we require the aspect of euthanasia actually in our country. And what is the aspect of euthanasia per se? Now let me discuss that there is a person who is in a permanent vegetative state for a number of years. It can be 20, 30, 40, whatsoever the case may be. Don't you think that there must be some situation or there must be some way in which that particular family is released or relaxed of such situation. Don't you think that unnecessary medical expenses in these terms must be curtailed for that particular family? So if there are no chances of arising of that person, coming to the living stage of that person, so these all ambits were taken care of in this case. And what the court came to conclusion that yes, there must be passive euthanasia, but this passive euthanasia must be in strict compliance with the legal principles, the legal requirements. So what was the case? It was for the legalizing the living will as well as the passive euthanasia. Now what did the constitution bench held in this case? The constitution bench of the Supreme Court decided the matter that right to life includes right to die. Right to die. It includes right to die. And it also went to held that passive euthanasia is justified. Not active, not active, but passive euthanasia is justified, but it should be subject to certain strict guidelines. It should be subject to certain strict guidelines. That is the legal guidelines. So it was held as such. Now, one more aspect that I would be taking care of in terms of right to life, that do we have, see, days and again, the metro cities are complained of that the environment is not good, that the level of water is not good, the purity of water is not good. So, does the right to life include right to healthy environment, right to pollution free water? And let me drag your attention to the case of MC Mehta versus Union of India. MC Mehta versus Union of India, and in short, if I say, it is the Sri Ram Food Fertilizer Company case. Sri Ram Food and Fertilizer Company case. See, there was a leakage from this company. Actually, let me put it in the brief way. First of all, the history of the case, that there was a company just behind Tees Hazari Court in New Delhi, and there was a leakage of gas that is called oleum gas. It is also known as oleum gas leak case, right? So there was leakage from this Sri Ram Food Fertilizer Company, the oleum gas, and led to death of one person and the injury of several other advocates in Tees Hazari Court. Now there was a public interest litigation filed before this. This case is also known for the reason that Honorable Justice Bhagwati went to hold the concept of absolute liability in this case only. So in this case, it was held that right to have right to life includes that is right to healthy environment, right to healthy environment, as well as right to have pollution free water. So environment must, a good environment, a proper environment is a must, because all of the day what is required is you need healthy environment, you need pollution free water for a better life. And since the right to life is the very fundamental right, right to life is the very fundamental right, as said in by Honorable Apex Court, that Article 21, which talks about right to life, is the heart of all fundamental rights. It is the most important, most precious right. And it is such a precious right that it can't be even curtailed during emergency. So if it is such an important right, definitely it will have the broadened facets. And in the days to come, we will be seeing that how our court is particularly recognizing the new types of right to life. So right to life does not mean that uh, just leading a life like animal existence is just not the right to life. It is something way beyond that you can think of. And in anything which is in a uh, position to deprive of your right to life should be curtailed accordingly. So I think we had a good journey in terms of the right to life, that is the fundamental right, which is the heart of all the fundamental rights as discussed by Honorable Apex Court. We had discussed on numerous judgments which are important. Still there are a number of judgments that can be discussed on this point. There are n number of judgments which can be discussed. It is a very broad concept. But before concluding this session, let me highlight some of the aspects in terms of that the law has taken a very big initiative in terms of especially the online students, that such students which are not in a position to come to the classes regularly should join classes at their ease, at their preference, and they should study at least from their home itself. So every possibility, every opportunity is given from our side. You are requested, you are suggested that you grab this opportunity of being a part of Dhelo and seeing the dreams of yours being completed, being achieved. Since it is also a precious aspect of your right to life. Thank you so much.